Debt and the Fair Debt Collection Practices Act. Hi, I'm consumer protection attorney Bill Clanton, and I've helped hundreds of consumers, regular folks like you and me, deal with debt collection harassment, inaccurate credit reporting, and other consumer-related matters. In this video, I'm going to talk about debt and the Fair Debt Collection Practices Act. This is a big topic, and this video is going to be longer than a lot of the others that I've done. So get your seatbelts on. Here we go. To better understand the landscape of debt and the collections business or situation that a lot of folks are in, it's important to understand debts. Now, the law recognizes two broad categories of debts: secured and unsecured debts. Secured debts are debts that are secured by some collateral, or collateralized debts or secured debts, which mean, and typically for most folks, these are car notes or mortgages, house notes. They are a debt that has something attached to it, some security attached to it, so that if a bank wants to foreclose or repossess the car or home, they have some asset they can take and apply against the note. And that's what happens. If somebody defaults on a mortgage note or a car note, then the bank forecloses or the bank repossesses the car. That asset, that home or that car, is sold at an auction typically. And what is recovered at the auction is applied against the balance on the note. If the car or the home fetches enough at auction to cover the note, then you're entitled to the surplus after fees and other costs are applied, of course. And it's typically the situation that I see, that the sale at the auction is not enough to cover the remainder of the note, then there's a deficiency balance, which the banks will pursue you for. Now, secured debts are typically collected, they're the most reliable form of debt. There's always something to recover. So banks typically hire lawyers, the most sophisticated type of debt collectors, to pursue those types of debts and to collect those debts. The deficiency balances are no longer secured because the security instrument has been, or the security has been sold. So the deficiency balance, banks often sell those to third-party debt collectors. Banks don't always collect that on their own. Unsecured debts. Unsecured debts include credit card debts, student loan debts, payday loan debts, medical debts. There's any other debt that's not secured by collateral is an unsecured debt. Credit card debts. Credit card debts are interesting in the way they work. Let's say you have a Capital One card. On January 1, you owe Capital One $1,000, and they send you a statement on January 1. Well, you have 45 days to pay that statement or make a payment or pay the minimum payment on that account. If by February 15th you don't make that payment, then you're considered delinquent, and fines and fees will be added to that account for 6 months. At the end of 6 months, if you still haven't made a payment or brought the account out of delinquency, then it will be charged off. Now, somebody with $1,000 balance on their Capital One card on January 1 may not recognize it as the same account because the amount may have doubled. It may be $2,000, even $2,500 at the end of August or middle of August. So, once it's charged off, there are no more fees that can be added to it. There's no more interest that can be charged to that account. It's the final balance at charge off. Now, Capital One and many of the other credit card issuers have agreements with debt collectors like Midland and Portfolio Recovery Associates to sell all of their charged off debt to them at a certain price, 5, 7, maybe less than 10 cents on the dollar. And they buy that and collect it. Sometimes they collect it on their own. Sometimes they send it out to third-party debt collectors to collect it, but it's out in collections. Some unsecured debts are federal debts. Federal student loans, federal medical debts for people who get taken to military hospitals. Those are two types of debts that are a little bit unusual. Federal debts the federal government can use the full force of the federal government to collect those debts. That means they can garnish your wages, something an ordinary debt collector in Texas could not do. They can garnish your IRS refunds. They can intercept those and use those to pay the balance. These debts are never really charged off. There's interest that's always accruing on them. Another type of debt that is common is rental debts or apartment debts. When somebody breaks a lease, gets evicted, or when somebody moves out and the landlord alleges that they have damaged an apartment or a home, and that damage is more than the security deposit, then there can be rental debts or apartment debts. These are not collected by the most sophisticated collection agencies. It's been my experience that these apartment debts are highly contested. Tenants usually believe they left the apartment in great condition. Landlords are always trying to replace blinds or rugs or carpets. And so they always say that there's more damage than there may actually be. So these are always contested debts, and the debt collectors that collect these debts, these are not prime debts for collections. They are a little bit less sophisticated, typically, and they often will make mistakes in collecting debts and violate the Fdcpa. Medical debt collectors, on the most part, are fairly skilled at collecting debts. Not always, but they do generally a good job. They're some of the sometimes they break the law, but not always. And payday lenders and collectors for title loans. These are the absolute bottom of the barrel collection agencies. They intentionally break the law. They hide their identities so they cannot be tracked down, or it's more difficult to track them down. I've had some success tracking them down. But if you're getting calls threatening arrest or saying they've sued you or giving you a case number that is bogus, then that's what they're collecting. They're collecting a charged off or sold payday loan debt. These debts sell for 2 to 2.5 cents on the dollar. And so anything they can collect, they'll try to collect anything they can to pay this off. Let's see. Unlawful collection conduct. Now, debt collectors collect all this type of debt, third-party debt collectors. And there's two laws that apply in Texas to third-party debt collectors. Of course, there's the Federal Fair Debt Collection Practices Act, and there's the Texas Finance Code, Chapter 392, also known as the Texas Debt Collection Act. These two laws give Texans a lot of protection from debt collection harassment and other aggressive collection methods. The Fdcpa applies to consumers. That's the person who took out the debt or allegedly took out the debt. It also applies to persons. Let's say you took out a debt and you listed your aunt or your uncle as a contact. If they call and harass your aunt and your uncle about the debt or disclose the debt to your aunt and your uncle when they shouldn't, then your aunt and your uncle will have claims under the Fdcpa, even though they're not the consumer. They're not you, the person who owes the debt, allegedly owes the debt. Now, the Fdcpa does not apply to businesses or trusts or other entities. It only applies to natural persons, real living human beings. Who is regulated by the Fdcpa? Third-party debt collectors and debt buyers who buy the debt with the intent to collect it or place it for collections. So there are thousands of debt collection agencies out there, and they are all covered by the Fdcpa if they are not the company that originated the debt. Now, a company that originates a debt can be a third-party debt collector if they use a name other than their true name. So in the Capital One example, if Capital One collected a debt in the name Capital Two, then they would be a debt collector for all the collections that took place in a name other than Capital One. So a an original creditor can be a debt collector, but most of them are smart enough to pass that job off to actual third-party debt collectors. The Texas Debt Collection Act covers both first and third-party debt collectors. What does the Fdcpa regulate? It regulates communications by debt collectors. Communication is any utterance made by any person through any medium. It's a very broad definition. But practically, what is it? Well, debt collectors communicate by phone, the classic debt collection method, calling somebody up and telling them to pay. They communicate by mail. Debt collectors still send lots and lots of letters. And these letters can be full of misrepresentations. If you receive a collection letter, it's important to hold on to it. They communicate by email. Now, not every debt collector communicates by email, but a lot of them are starting to contact people by email. And courts are starting to recognize this as a collections method, there's some law beginning to develop around it. Text message. Some debt collectors communicate by text message. Now, debt collectors who use an auto dialer to call you or to send you text messages have to comply with the TCPA, or the Telephone Consumer Protection Act. This says that they have to have your prior express consent before they use an auto dialer to contact you. Very important. And it also says that they have to stop contacting you if you request them to stop. Who can a debt collector contact? They can contact you. But they can only contact you when it's convenient, and they have to stop if you tell them it's an inconvenient time to contact you. For example, if they call you at work, you can tell them, I'm at work, this is not a convenient time, please call me at another time. And they'll have to stop calling you when you're at work. They can talk to third parties, your aunt and your uncle, like in the previous example, but they cannot tell your aunt or your uncle or whoever the third party is that they're trying to collect a debt, and they can only give out their name if they're asked who they are. This is a common violation. Debt collectors will try to find somebody and say, can you tell him to call me? He owes us money. Well, that's a violation of the law. Ceasing communication. Debt collectors have to stop communicating with you if you send them a letter. Telling them to stop calling is not enough under the Fdcpa. You have to write them a letter and tell them one of two things. You refuse to pay the debt, or to stop contacting you. Either one of those will work, and either one of those, after receiving that letter, they have to stop contacting you. When you tell them that it's an inconvenient time to receive a call, or if they know you're represented by counsel, if you hire a lawyer and that lawyer sends a letter to the debt collector, they'll have to stop contacting you. And this is another common violation. If you've hired a lawyer and that lawyer has filed an answer for you in court or has sent a letter to the debt collector, then if you receive communications from that debt collector, it's not your lawyer's fault. The problem's not with your lawyer. The problem's with the debt collector. And your lawyer needs to know about that communication right away, because that debt collector has violated the law, and you now have a case against that debt collector for violating the law. Harassment and abuse. The Fdcpa has broken into a few broad categories. Harassment and abuse is one of those categories. And it lists several types of actions that are harassment and abuse. Using profanity, threatening somebody with physical violence or harm to their reputation, calling somebody repeatedly or continuously with the intent to annoy or harass them, not saying who they are when they call you, using obscenities or profanities. If a debt collector calls you a deadbeat or worse, then that's a violation of the Fdcpa. Any of these things are violations of the Fdcpa. False or misleading representations are another broad category of violations of the Fdcpa. I'm going to go over a few of these specifically, but generally, false and misleading representations are prohibited by the Fdcpa. The Fdcpa provides 16 different types of false or misleading representations. But one of the most common is a false or misleading representation of the character, amount, or legal status of the debt. This is contained in 15 U.S.C. 1692 E2A. It says that a false or misleading representation about the character, amount, or legal status of the debt is a violation. What does that mean? Well, the character of a debt, whether it's within the statute of limitations, whether it's disputed, anything to do with the character of the debt, if they falsely represent it, make a false representation about that, that's a violation of the Fdcpa. The amount of the debt. Now, you would think that a debt collector, if they could get anything right, it would be the amount of the debt they're trying to collect. But it's not. I've seen debt collectors send a letter for one amount, file a lawsuit for a second amount, and report on a credit report a third amount. How? Well, they do it, and it's a violation. If a debt collector gives you two different amounts for the same debt, they can't both be right. And with three amounts, it's even worse. So if you're getting a debt collector telling you have different amounts for the same debt, that's a violation of the Fdcpa. And the legal status. How can a debt collector misrepresent the legal status of a debt? Well, by telling you that a lawsuit has been filed when it hasn't, or telling you that a debt is within the statute of limitations when it's not. There are all kinds of ways a debt collector can misrepresent the legal status of the debt, and those are just a couple of them. The false representation that an attorney, or that a communication is from an attorney, or that a person is an attorney. Now, it seems like this would be hard to mess up, but it's actually pretty easy. If somebody calls you and says they're an attorney, they'd better be an attorney. Now, an attorney's time is more expensive than a frontline telephone person at a debt collection outfit. And so a debt collector is unlikely to put an attorney on the phone calling people trying to get them to pay. They're more likely to put a frontline telephone worker on the line, and save attorneys for more important work, or work that generates more revenue. So attorneys will send letters. Now, if attorneys sit there and robo-sign letters, they're not involved in the case, and a representation of that letter that they are is false. So an attorney has to have some meaningful involvement. An attorney's signature means that that attorney has been meaningfully involved in the production or sending of that letter. If that letter has other problems, like it misstates the amount of the debt or the legal status of the debt, then it can show that an attorney was not meaningfully involved in the production or review of that letter. And those can be good cases too. Threats to take an action that a debt collector cannot take or does not intend to take are a violation of the Fdcpa. Saying that they intend to sue you or they intend to add interest onto a charged off debt, those are threats to take an action they cannot legally take and are violations of the Fdcpa. In Texas, a debt collector cannot garnish your wages. So if a debt collector tells you that they're going to garnish your wages in Texas, then they violated the law. False credit reporting. Now, a debt collector has to report truthfully and accurately the information they have. If they know or should know that information is incorrect, they cannot report it, including whether or not you've disputed the debt. If you've disputed a debt, the debt collector has to report that debt as disputed. Credit reports should be checked carefully. They often contain errors by debt collectors that are actionable. Oftentimes, a debt collector will report on your credit report before they send you a letter. So keep an eye on your credit report and see if anything pops up there, because sometimes they will report on your credit report before they send you a letter or do any further action. False or misleading representations are against the rules or against the Fdcpa. A couple of other deceptive tactics that debt collectors use is telling you that legal documents do not require a response when they actually do, or telling you that documents require a response when they do not. Accusing you of committing a crime. That's a slam dunk Fdcpa case. So why should you be on the lookout for these types of activities by debt collectors? Well, because the Fdcpa gives you a way to turn the tables on debt collectors. It gives you a case against the debt collectors. It also gives you actual damages. Now, it can be hard to say that misrepresentation of an amount of a debt is it costs you money or costs you some actual damages. But if that misrepresentation is that you owe more than you actually do and you pay more than you actually do, then you've suffered actual monetary damages. People who are being harassed or pursued by debt collectors aggressively may have some damages, some mental anguish or emotional distress that is compensable as actual damages. But if a debt collector fails to give you notice or miswords something, then these cases don't always have actual damages. And the Fdcpa provides for statutory damages up to $1,000 per case. That's not per claim or per violation, it's per case brought under the Fdcpa. The Fdcpa also says the debt collector has to pay your attorney's fees on the successful resolution of the case and your costs. So if you're looking to hire an Fdcpa lawyer, they should not charge you anything to take your case because at the end of the case, they'll be compensated by the debt collector. Oh, and sometimes debt collectors offer to extinguish the debt as part of the settlement of an Fdcpa case. Not always, but sometimes that's a term that they'll agree to. The Texas law, the Texas Debt Collection Act, has a few key differences. There are no statutory damages except for very specific violations. And but it also allows for an injunction. It allows for you to enjoin the debt collector from contacting you or otherwise harassing you. Now, the Texas law is interesting in that it requires debt collectors to have a bond on file with the Texas Secretary of State. You can Google Texas Secretary of State debt collector bond, and you'll go to the search engine for debt collector bonds. There's a little over 2,000 debt collectors in there that have active bonds on file with the Secretary of State. And this is a good way to find out if a debt collector is legitimate or not. There are some special provisions in the Texas law regarding disputes, but generally the same activities are prohibited. It's basically the same law. There's a few minor differences. And the Texas law applies to first-party debt collectors also. So back to Capital One in that example, they have to follow the Texas Debt Collection Act when they're collecting their own debts. The collections industry, just to give you an idea about the collections industry, Midland and Portfolio Recovery Associates are two of the biggest debt collectors that are around these days. Midland is owned by Encore Capital Group. They're a publicly traded company. They have shares on the stock market that are traded back and forth by investors. Encore owns another company called Cabot. Cabot collects debts in England and Ireland, but Midland is Encore's branch in the United States. As a publicly traded company, Encore has to file a 10-K, a statement, with the Securities and Exchange Commission, the SEC, every year. It reports about their business and about their income. In 2019, Midland was able to collect $1.2 billion with a B from struggling consumers all over the world. It's an incredible amount of money to squeeze out of people, but they did it. Now, Portfolio Recovery Associates came in behind Midland. They collected a little over $1 billion last year. It's incredible that over $2 billion was squeezed out of the pockets of struggling consumers last year. but that's what the reports say. Before you make a payment to a debt collector, you need to verify that it's a real debt collector. A good way to do that is to first check your credit report and see if they're listing this debt on your credit report. Most shady debt collection companies and most scammers cannot or will not report on your credit report about a debt. If you don't see it on your credit report, or even if you do, look this company up on that Secretary of State database and see if they're in there. If they're in there and they have an active bond, then they're probably a legitimate debt collector. Verify the debt. Send a letter requesting verification of the debt. In that letter, you can also dispute the debt. Check your credit report to make sure it's updated with the dispute information. Request an offer in writing. If a debt collector is contacting you by phone, ask them to send it to you in writing. If they won't do it or can't do it, then they're not a legitimate debt collector. Don't get in a hurry to make a deal with a debt collector. The deals they offer will always be re-offered. They're always willing to discount a debt to make a deal and make money. They're only looking to collect money any way they can. If you like an offer, tell them to send it to you in writing. Stop the harassment. Here's how you do it. Send them a letter. Tell them to stop calling. Give them a time of day that's convenient for you to stop calling. Or hire a lawyer to send them a letter of representation. Bankruptcy. Some folks feel like they're so over their head in debt that they can never pay it back. Bankruptcy offers an option for folks. There are generally two types of consumer bankruptcies out there, Chapter 7 and Chapter 13. Chapter 7 is the fresh start bankruptcy. It takes about 3 months and wipes out all your unsecured debt. You should be able to hold on to most of your secured debt through reaffirmation, but your agreements on those debts may say that if you file bankruptcy, you default on those. Chapter 13 is a restructuring. You'll be entered into a 5-year restructuring plan. You'll make payments to the trustee or the court, who will then distribute those payments out to your creditors. Debt collection lawsuits. At the end of the collections process, most debt collectors will turn the accounts over to lawyers to sue you. Not always, but lots of times this happens. There's a 4-year statute of limitations for most debts in the state of Texas. So they have 4 years from your date of first delinquency to sue you. Hundreds of thousands of these lawsuits are filed in Texas every year. In 2019, there was between 300 and 500,000 of these lawsuits filed across the state. And the worst part about this is that 90% of these lawsuits wound up with a no answer default judgment. That means the consumer was sued and served, or at least a process server signed an affidavit saying they served the consumer, and then the consumer didn't answer. The deadline was blown, and the debt collector got a default judgment where the court says that the consumer, by not answering, agreed with the debt collector that they owed the debt. If you get served with a lawsuit, don't worry. This happens to hundreds of thousands of people every year in the state of Texas. Did you know that 44% of Texans have debts that are in collections? It's incredible the number of people who have debts in collections. Now, if you are sued, it's important that you file an answer. Oftentimes, courts will have forms, or clerks at the courts will have forms for you to file an answer with. I'm a lawyer, I'm biased, but if you get sued, you should hire a lawyer. A lawyer can do discovery, can negotiate a settlement, or make the debt collector prove they have the documents and the proof to prove their case. Lots of times they don't, because debt collectors buy debt from the banks that issue it, or there's even a secondary market from the debt collection the first line debt collection companies themselves. These documents get lost or become unreadable. And they don't even have the documents in the first place sometimes. So it's important to hire a lawyer so you can put up all your defenses and identify any potential counterclaims you may have. Now, a judgment is a powerful tool. If a debt collector gets a judgment against you, they can use this. It's a whole new set of tools they can use. Garnishment. They can garnish your bank account. Now, like I said, wage garnishment is illegal in Texas, but they can file a lawsuit against your bank, and your bank will have to pay whatever's in your account to satisfy the judgment. Receivership. Now, receivership used to be a lot less common, but in 2017, the Texas legislature amended the law to make it easier to have receivers appointed, and the debt collectors have had a field day with this. They will get a receiver appointed, and the receiver will add a 25% fee. So your judgment just went up by 25%. And they're given incredible power. They can pull your credit report. All they have to do to freeze your bank account is send the bank a letter. I've had clients who've gone out to dinner and then used their debit card to try to pay for it, to find out a receiver has frozen their bank account, or to pay for groceries. It's a powerful tool that debt collectors are using more and more often to try to squeeze more money out of consumers. An abstracted judgment. A debt collector can abstract a judgment. That means they file it in the official public records. It's not a lien against your home, but if you sell your home, the title company won't clear the sale until you take care of that judgment. That's a bit about debt collection and debts in the state of Texas. I hope you found this helpful. If you have any questions, feel free to call me or reach out to me at the number below. And thanks for watching.